You are welcome to yet another episode of HN What's Your Say? The #1 listening show, where we discuss real issues with real people like you. We are still featuring R. Kelly. Real name Robert Sylvester Kelly. Also known as the R&B King. Every person who enters an American courtroom is promised the same thing: the right to a fair trial and the right to counsel that operates without interference. Those guarantees sit at the heart of the 6th and 14th Amendments. The defense has long maintained that when these promises are placed in jeopardy, the entire system of justice begins to erode. In R. Kelly's situation, defense attorneys argue that the secrecy surrounding federal investigations into possible access to his prison communications represents one of those moments where transparency becomes essential. When a defendant is detained before trial, all correspondence with counsel, whether by mail, phone, or electronic message, is supposed to remain confidential. That privacy is not a luxury, it is the mechanism through which strategy is built, evidence is reviewed, and the client can speak freely. If anyone within government channels obtained or viewed that information without authorization, the defense insists that it would undermine the very definition of a fair process. They point to decades of precedent where courts have ruled that even the appearance of government intrusion into privileged communication can justify post-conviction review or a new trial. From the defense's perspective, this is not about fame or celebrity. It is about whether the same Constitution that protects ordinary citizens still protects someone whose name has been tried in the court of public opinion.
The invasion of his privacy, the stealing of his emails, using those emails, selling them to bloggers or giving them to bloggers for some type of gain, intruding in his private life, leaking material to the press about how much money he has in his commissary account. This is coming from BOP officers. So there is criminality occurring.
When reports emerged that federal agencies were investigating improper access to R. Kelly's recorded calls and emails, the defense viewed it as confirmation of what they had feared, that confidential exchanges might have been exposed. Yet the official findings of that investigation remain sealed. For a defense attorney, the withholding of such material is not a small procedural matter. It deprives the accused of evidence that could demonstrate how his trial was affected. The 6th Amendment promises effective assistance of counsel, and that promise carries an implied shield: the government cannot listen in on the preparation of its opponent. The 14th Amendment extends that protection through due process, ensuring that the state does not gain advantage through unlawful means. Defense lawyers therefore argue that if privileged material influenced prosecution strategy, witness interviews, or trial preparation, it would represent a constitutional violation that cannot be ignored. Even if the information was never used in court, the possibility that it shaped internal decisions would be enough to compromise the integrity of the verdict. Legal history supports this reasoning. In numerous appellate decisions, courts have vacated convictions where the prosecution gained access, direct or indirect, to attorney-client communications. The reasoning is consistent: justice must not only be done, it must be seen to be done. Without transparency, no one can know whether the scales were tipped. That is why the defense now calls for full disclosure of any federal findings related to R. Kelly's detention period. They argue that secrecy in this context protects no one except those who may have breached protocol. The defense also points to the atmosphere surrounding the case: a climate charged by media narratives, public pressure, and a government eager to appear tough on misconduct in the entertainment world. In such an environment, even minor procedural violations take on greater meaning. If investigators or prosecutors received information that should have remained private, it could have subtly informed witness preparation or cross-examination strategies.
Beat me with a shoe, a size 12 foot Air Force One, and he beat me all over, which felt like hours, and I was whelped.
The defense maintains that courts cannot simply presume harmlessness, they must demand proof that no advantage was gained. Supporters of this view note that the Department of Justice has in other instances publicly released summaries of internal investigations when the integrity of a trial was at stake. Doing so here, they argue, would not weaken the government's case. It would strengthen public trust. The refusal to disclose, by contrast, feeds suspicion that the playing field was uneven from the start. The defense's larger message reaches beyond one defendant. It questions how many other pretrial detainees may have had their privacy compromised without their knowledge. If the system tolerates that possibility for a high-profile case, what protections exist for those without fame or resources? This is why the defense frames the issue not as a celebrity controversy but as a test of constitutional fidelity. The Constitution does not bend according to public opinion, and the presumption of innocence does not expire when headlines turn hostile. In appellate filings, lawyers typically emphasize that due process demands remedies, not just acknowledgement. When the fairness of a trial is in doubt, courts possess several tools: ordering evidentiary hearings, compelling disclosure of investigative records, or even granting a new trial. The defense argues that these remedies are not extraordinary. They are the ordinary response when constitutional rights may have been compromised. For the broader public, the question is simple: should the government ever benefit from information it was not entitled to see? The answer in principle is no. Yet the lack of transparency leaves the impression that rules can be bent when the defendant is unpopular. That perception alone erodes confidence in the justice system. The Sixth Amendment's promise of counsel and the 14th Amendment's command of due process were designed to stand firm against exactly this kind of uncertainty. The defense continues to urge courts to demand the release of the investigative report, to review whether any evidence or witness preparation was influenced, and to grant relief if the findings confirm a breach. Until that transparency is achieved, the legitimacy of the conviction remains open to challenge. At the end of the day, this issue is about fairness, not fame. The right to a fair trial is the one thing that equalizes every person before the law. Whether the defendant is a musician, a laborer, or an ordinary citizen, that right cannot depend on the discretion of those in power. The defense's appeal is simple: open the files, follow the evidence, and let the truth determine the outcome. Only then can the public have confidence that justice in America remains blind and that constitutional promises still mean what they say. That is all we had for you today on HN What's Your Say? To keep updated whenever we post a new video, subscribe to this channel now. Also remember to hit the bell icon and enable notifications. And feel free to share your opinions with us in the comment section below, and let us know if you would like us to publish your views in our next release. We value all our subscribers' opinions.